freedom across the continent. Now we're going to play a video that will tell you a little bit about who AIRA is before we proceed with the session. In just a minute, the video will be up. Thank you. Okay, so as we wait for the video, I'll just tell you who the members of the Alliance are. The members of the Alliance include Paradigm Initiative, our host for DRIF. It includes Policy. We also have CIPESA that works in Eastern Southern Africa, Article 19, the East African Office, Amnesty International, their regional office based out of Nairobi, Kenya. We also have Budget based in Nigeria. All of these are members of the African Internet Rights Alliance. So it seems like the video may not be able to be played, so perhaps we'll play it towards the end. I would now like to invite Catherine. Catherine Muya works with Article 19. Article 19 is one of our members at AIRA, and she will be moderating this very important session. You're welcome, Catherine.
Thank you so much, Ashnard. So good evening, good afternoon, everyone. My name is Catherine Muya, and as she said, I am the Program Officer for Digital at Article 19 Eastern Africa. So today we are going to be talking about internet shutdowns and the role of the judiciary in supporting digital rights. And for this important topic, I am joined by 4 panelists who I will have the pleasure of inviting. Peter, I see you renamed yourself, so that's that's a good thing. So I'm going to start with my first, with my first panelist, who will be Victor. Sorry, yeah, Victor. Is Victor on the call?
Yes, good afternoon, everybody. My name is Victor Kapia from Kicktight, who is also a member of the AIRA Coalition.
Thank you so much, Victor. Next, we have Edrin. Is Edrin on the call? I'm not very sure. Okay, so while we're waiting for Edrin, maybe Peter, you could introduce yourself.
Thanks, Catherine. Hi, everyone. I'm Peter Misek. I'm General Counsel, lead the legal arm at Access Now. We're a global digital rights group. I'm based in New York City, and I teach at Columbia University as well. Nice to join you.
Thank you. Is Catherine on the call? And I know this will probably be a little confusing. Catherine Arnott?
Hello, my name is Catherine Anite from Small Media Foundation and the Freedom of Expression Hub. Glad to be here today.
Okay, thank you so much for introducing yourself. So first I want to mention that this is AIRA's second session at DRIF. Basically, we had our first session last year, and this is our second session. I will invite you to follow us and check out the work that we've been doing as the African Alliance. So you can check out our Facebook, Twitter, and LinkedIn page. It's all at AIRA, so that should be easy for you to find. And our website is also aira.africa. Maybe we could have Brian help us with posting this information on the chat, and you could be able to just find us and reach out to us in case you have any more questions. So right to begin, so that we are very in time and cautious of time, I will invite Victor to begin and tell us more about the study that we did and the findings that we had. So in 2021, AIRA commissioned a study on internet shutdowns in Africa, which was especially important because we had seen at least 14 countries in the previous year experiencing internet shutdowns, which is one of the highest numbers of internet shutdowns from 2015 that were recorded. So Victor and his colleagues then did a study on this. And we're happy to report that we'll be launching this report now and also finding out more about the study. So Victor, please feel welcome.
Thank you very much. I don't know if you can see the screen.
So we can see that you're sharing, but we're still, okay, yeah, we can see it now.
Okay, great. So this study was conducted last year with my colleagues who are not present today, Sigi Waigumo and Odanga Madu, and myself. And just want to share some of the key findings that emerged from the study. And, as you can see there, in the past, we've had shutdowns in more than, we were spotlighting 10 countries, and you can see in those countries, there have been 44 orders. There have been 4 types of different shutdowns. The justifications for shutdowns have been multiple, and the total number of days has been 779. And collectively, we've had 51 shutdowns in the continent, which is problematic by its very self, and you can see the spread across those key countries. So basically, one of the things our studies found is that between 2016 and 2021, there were 68 shutdowns in 29 African countries, which basically means and demonstrates that government-mandated shutdowns and disruptions are slowly becoming a norm. If we have more than half the countries in the continent experiencing a shutdown at some point. And of course, there's very little scientific or social evidence to demonstrate the effectiveness. And we also looked at some of the factors that actually, inform the possibility of conducting shutdowns, and we see that we try to analyze the countries, and we noted that you will find shutdowns in countries where there are authoritarian regimes, and in the countries where shutdowns have also occurred, most of the president's terms have had quite a long duration in office. In those countries, there are also laws and policies which facilitate shutdowns. The shutdowns have also been conducted or implemented during periods of protests or national examinations, and also during election seasons. And what we also see is that the impact of these shutdowns is that it has adversely affected civil and political rights mostly, but also access to internet and moreover social and economic development, noting the fact that many people in the continent now are using the internet for multiple purposes, as the COVID period has shown us. We're using it for work, commerce, education. So when the internet is shut down, then there's a much bigger effect than what is actually seen. The other observation is that the shutdowns are usually ordered by the executive arm of government in most cases. It's implemented by private actors, basically the telecom companies and internet service providers. And one of the things we also noted is that these private observers usually will comply with shutdown orders, and they base it on the obligations under national law, and we also see licensing agreements obligations, which regulators and governments usually cite, saying that you are bound to respect government orders or any directions from governments, even in the absence of clear laws. And we also see the effect of political influence and also the legal context, the state of development of countries, the political environment being, providing an opportunity in terms of how rights are respected. The Methods that we've noted as used to facilitate shutdowns include throttling. In most countries, it's common, but is not well documented in terms of its effect, because most people, you find, because we don't know, you think it is a problem with the internet, but in actual fact, it's actually intentional slowing down of speeds. We've also noticed IP blocking, mobile data shutoffs, DNS interference, server name identification blocking, and the packet inspection are some of the methods that are used by states. And we also looked at what is the kind of pushback that is coming up from civil society in the continent. And we've noticed that increasingly there is better and more documentation of these shutdowns as they occur. There is increasing body of research. Of course, now that Peter is here, the Keep It On coalition, the AIRA coalition, and others who are actually documenting these shutdowns as they occur. We have the UNI tools that actually are used for network measurements being at least deployed in different countries to actually establish the shutdowns. We've also noticed public interest litigation emerging as a useful tool for contesting the legality of shutdowns before national and regional courts, especially with, very good decisions emerging from, the ECOWAS court, for example. And just looking at, other work by civil society, such as, increasing partnerships to monitor shutdowns within countries, regular convenings that are actually talking about internet shutdowns as a critical topic for conversation. We've seen also the training of litigators being done in some parts, because we realize that it's a very important aspect to push back against shutdowns. And we also looked at some of the cases that have been litigated in national and local courts, and some of the issues that usually are contested are, who should the parties be and who should be sued, what human rights issues should be brought before. We've also noticed the rule of law breaches being raised in court documents, and also the economic impact of shutdowns and some of the key issues being brought before courts. And the pushback in some of this litigation by governments has been, arguments around locus standi, saying that the parties who are suing the states don't have the capacity or the standing to sue, or raising national security reasons, saying that, these are actually important. The state needed to take these measures. And of course, we've seen how courts have taken action by restating the importance of the rights to access to internet, especially in the ECOWAS court, and also restating and re-emphasizing the importance and the position under international human rights law regarding restrictions on freedom of expression, freedom of association and assembly online. We also noted that there are certain barriers to strategic public interest litigation. We noticed that across different countries, we have weakened legislative and judicial institutions, especially in the countries where the shutdowns occur. Noting previously, as I mentioned, that some of these countries, have authoritarian leaders, and strong authoritarian executives do not like strong independent legislatures and judicial institutions. So in those environments where these two key checks and balances are weakened, then it provides a ripe environment for shutdowns to be conducted. And of course, it goes to the enforceability of court orders, because these are not often respected in these jurisdictions, because the courts are fearful of making that decisions, and even when they are made, then there is no incentive for them, court orders, to be respected. And as I conclude, We highlight a couple of recommendations for AIRA Coalition and other civil society organizations is to, conduct or, adopt a multi-pronged approach to research, advocacy, and communication, including capacity building and, strengthening the networks to fight shutdowns, and to leverage on members' networks to encourage more civil society organizations to join these coalitions and campaigns to contest and push back against internet shutdowns. We need to build more capacity and enhance, the monitoring and reporting of internet shutdowns. One of the challenges we experienced in the research was that, we don't have robust and comprehensive information on when the shutdowns are occurring, and probably there are some that occur and we are not aware. So the documentation, and we really appreciate the work done by Access Now in documenting and keeping a regular database of these things when they happen. And we also noted the importance of actually engaging the private sector, companies, the ISPs and the telcos who actually hold the switches to shutting down the internet. And one of the things we've noticed is that there's an increasing, a slight increase in the number of telcos who are starting to adopt human rights policies, such as, MTN and, Safaricom and, SDGs and stuff. But I think it is important for civil society to engage and hold these companies to account for, and to make them take a position and also push back against, orders to shut down or to slow down or to throttle, internet in the jurisdictions where they practice, and to come out publicly to oppose the shutdowns, and also to notify members of the public that shutdowns are actually, they've been given orders. And we noted, particularly in Uganda, where some of the ISPs actually shared information and indicated that, we have received an order from the government to shut it down, and we're going to shut it down. But you see, it shouldn't stop there, and they could do more to push back. And of course, we note that, judiciaries remain critical institutions, and, civil society could collaborate with the judicial training institutions at national and regional levels to boost and enhance the capacity of judicial officers on digital rights, but at the same time to highlight for them the concerns around digital rights issues that are emerging in the continent, so that then, as part of one of the issues when we reviewed the decisions, we find that there are certain challenges in terms of the appreciation of digital rights, and also, international principles, norms, and soft law around digital rights issues. And it's important that we continue to engage with these judiciary training institutions, so that the content around digital rights is integrated within the curriculums for judicial officers. And I think also by extension, bar associations and lawyers associations across the continent. And with those many remarks, thank you very much.
Thank you very much, Victor, for highlighting. If I could pick out maybe just a few of the key things that you said were, of course, the need in terms of findings is how internet shutdowns occur in authoritarian governments, and also how difficult it is sometimes for these entities within those countries to push back, and then highlighting the role of telecommunication organizations and operators in terms of fighting back and being more transparent and incorporating more business and human rights principles that then speak to not shutting down the internet. And then your recommendations, or if I could just point out, is the need for us to work collaboratively together, right? And also just highlighting more on the work that's being done on litigation. And you've mentioned a lot of the work that Access Now has done in the Keep It On Coalition, and I see Peter has changed his background. So Peter, as Victor mentioned, your organization does a lot to work on internet shutdowns. So I would invite you to just make your remarks on anything that Victor has said and everything that you want to add on.
Thank you so much, Catherine and Victor. That was a wonderful presentation. I don't have much to add. I can just pull out, I think, and highlight some of the findings. Yeah, I work at Access Now. We are a global we are a global digital rights organization, and we certainly have prioritized internet shutdowns as one of the key threats to digital rights globally that we focus on. And our Keep It On campaign, which a lot of folks here are key members of, is coordinated out of West Africa. And that region, unfortunately, according to our latest data across Africa, actually, there are some worrisome trends. Excuse me, it's a little early in New York, but we've seen some progress fighting shutdowns, and I think Victor showed some pretty much all of the key kind of organizing tactics that we're using. One tactic that we really have focused on at Access Now and the Keep It On Coalition is election monitoring. So we are in a better place to address the impacts of shutdowns, to fight to end internet shutdowns, and stop those ones that are occurring when we can predict when they're going to happen. And for us, that's meant looking at elections calendars and trying to see, did this country shut down the internet in the previous election cycle? Are they more likely to do so again? And I don't have the data in front of me, but I'm pretty sure once a country and once a government does shut down the internet, they're more likely to become a repeat offender, and see that as, again, as a tool and as a normal way to deal with the internet, which we all, I hope we can say we have rough consensus that internet shutdowns are not an effective tool of internet policymaking, and don't, either through process or impact, help advance the cause of human rights and economic and social development in the digital age. So with those things settled, I think I can talk a little bit more about our work around elections and litigation, but I do first want to preview some of the numbers from our reporting on shutdowns in 2021. So our Keep It On report, we try to put out annual reports tabulating internet shutdowns globally. We hope to get that report out later this month, but I can say that, again, we see worrisome trends in Africa. We saw, more shutdowns cases in Africa in 2021 than in the year before, perhaps around 10% more. And even worse, we saw more first-time offenders compared to 2020 and previous years, which is very concerning. And so in 2021, Niger, Senegal, and Congo shut down the internet for the first time that we know of. Again, citing Victor's comments there, that it's surprisingly difficult actually to document when shutdowns occur. But according to the data that we collect at Access Now and through all of our Keep It On partners, Niger, Senegal, and Congo shut down the internet for the first time ever in 2021. And we do not want to see that become a trend. So governments are also becoming more sophisticated in imposing shutdowns. They're using various methods, as Victor showed, throttling, maybe just shutting down one service like Twitter. Saw that in Nigeria. Or they're shutting it off and turning it back on, shutting it off, turning it back on, and just creating a situation of instability where you can't trust that you will have access at any given point. And all of this creates insecurity and, again, stops our advancement towards realization of human rights and development online. So we see this sophistication in a few countries, and definitely are also tracking the sale of new technologies to governments to help them filter and censor, right? So we're tracking the sale and the spread of censorship technologies, often from European or Western vendors being sold to governments, especially in East Africa. We've seen a few of these lately, and we believe that these kind of filtering and deep packet inspection tools are often abused to censor. So that is a trend that we should highlight in this report. And yeah, so that's some of the negatives, I think, that are coming out. I don't have the full number of shutdowns in Africa. It's in 2021. I know in the first in the first few months we saw 21. So that is, of course, too many. So if I could talk a little bit more about our response, unless you want to move on or ask a question.
No, I'll ask you questions at the end, but I'm really curious to hear about your response as well.
Great. So thanks. Yeah, and definitely channeling Felicia Antonio, who leads our Keep It On coalition based in Ghana, and Marianne, who's helped this year. We have, again, focused on elections. We want to put resources in place to quickly respond to shutdowns, but also to actually prevent, to have a voice and say, hey, you shut down the internet before. We don't think this is something that should be repeated. So in this upcoming election, here's all the reasons why you shouldn't shut down the internet. And, here's some support and some resources to help navigate, the problems that authorities might face, whether it's, the spread of disinformation and fake news, or, unrest and threats of violence. That's the sort of stuff that does, of course, come up online, but that we see better tools to use to prevent and mitigate than shutdowns. So we are really happy to report that our advocacy in the Keep It On coalition, we think, helped prevent shutdowns in Benin before the April 2020 election. And again, that's a country that had shut down the internet before during elections. We intervened with an open letter, to Keep It On coalition, before that 2020 election in Benin, and they did not shut down the internet. Similarly, in Gambia, before the December 2021 elections, issued an open letter. And during those elections, we did not see a repeat of the shutdowns that had occurred in 2016. So that's in Gambia. And then finally in Chad, they had really tweaked and manipulated the internet for over a year in 2018 to 2019. And so we were concerned about repeat offense in 2021 before presidential election in Chad. We issued an open letter. We did see, unfortunately, some shutdowns triggered by protests before Chad's elections in 2021, but nothing during the election. And so we do consider that a bit of a victory. And then, we also go to court, right? And court, obviously, you're responding, you're reacting to shutdowns that occurred. You're trying to find accountability, but also hopefully set precedents that that this is not to be repeated. And we did go to court supporting litigation brought in the ECOWAS courts around Nigeria's shutdown of Twitter. We do consider that an internet shutdown, even though it's targeting one service. And it was a great coalition sprung up. I know Paradigm and Serap and others in Nigeria led that litigation that we were happy to come in with an intervention and amicus brief on. And we're really hopeful for a good ruling. I think that'll come out next month from the ECOWAS court. And then in Zambia, there was an intervention. We just found out after the fact. And so that, I think, tells us we have more work to do to expand our network of digital rights litigators and to see this litigation coming. But that Zambian court did issue a really interesting ruling saying that authorities should not act outside of their regulatory powers. And they did bring the shutdown to an end on August 15th. But the court then went further and said that the Zambian authorities should provide notice of shutdowns within 36 hours of the event. And so that was an interesting ruling in that they actually set a time period and notice, requirement on authorities who do want to disrupt the internet. So I think we're moving towards a sort of regulatory response if that court ruling is indicative. All right, I'll stop there. I know I talked a lot. Thanks.
I think I really enjoyed hearing a bit of what you said, and I think some things that stood out for me was you talking about export controls to countries, to African countries, of censorship material. I think that's important, and I will come back to you to ask a question about that. And also some of the advocacy responses that Access Now is spearheading, including the one that they're spearheading and working with us in Kenya. But now I want to invite my namesake Catherine, mostly just because the last thing you talked about was litigation. And I want to ask her about the work that the Freedom of Expression Hub is doing. As an organization that supports freedom of expression, I deeply and passionately want to hear what the interventions that they have, including how they're engaging the judiciary in supporting and advocating for digital rights and free expression and an end to internet shutdowns. Catherine? Catherine, she was just on the call. I just saw her as you were speaking. I think she's even unmuted, but has...
She's on. I think she's having trouble with her Wi-Fi.
Okay. No worries. Catherine? I'm also not sure if Adrian was finally able to join us.
Adrian is also on the call.
Okay. So as we give Catherine some time to work out her connection issues, I will then invite Adrian to just come in and tell us more about the work that CPESA is doing in terms of also litigating and the use of litigation. There's an interesting case that also came out of Uganda, so I hope he'll mention it. Adrian? Okay, so I can see him raise a hand as an attendee. Probably maybe you could upgrade him to panelist.
Hello. Yeah, so thank you very much. I wasn't hearing anything, but great enough.
I'm sorry, did we lose you, Edwin? Edwin, sorry. Edwin, I think you're still muted. Perhaps you have to. Okay.
Thank you very much. Now I can speak. Of course, I'd joined as a participant and was trying to join as panelist, but I wasn't able to get in. So maybe CPESA, I'll seek for your pardon on what you want me to speak about, so that I go straight to what you want, the scope and the extent which I'm supposed to speak.
Well, so just maybe speak about maybe your experience on litigating on digital rights, and then also if it has any relations to the topic that we have, internet shutdowns.
Okay, thank you very much. As you all know, CPESA is a leading center for policy research, which aims at an enabling environment for improved livelihoods of the individual, especially as far as the digital space is concerned. From our work that we've been doing, of course, we've been supporting digital rights litigation here in one way or another, including, for example, joining the team that is litigating by providing evidence as one of the things, evidence through affidavits, and also joining as amicus to the different cases. But we have also been involved in capacity building of organizations and individuals to effectively engage in digital rights litigation through various platforms. So that said, one of the areas that we have established, or the key findings from this, for example, include, we've seen, as for example, Victor was highlighting, increased number of cases, especially of regressive measures against digital rights in Africa, controls, surveillance, and interception across the continent from the different countries or states. Secondly, we have also seen that the internet is currently a key enabler for the realization of other rights, such as freedom of expression, access to information, health, and democracy. And this, of course, is building up the heat for which litigation cases would arise. Then we have also established so many issues that affect the digital space, and we discover that most of these issues are actually multifaceted in nature. One leads to the other. For example, when you're speaking about privacy, you're speaking about surveillance, you're talking about interception, monitoring, you find that all these are interlinked. Then, of course, from what you would even have found in the report, our findings show that courts are actually of late less willing to make very progressive decisions on digital rights. This has happened in Kenya, in Uganda, save for South Sudan, a country which we have seen, of course, as having made some progressive, but most of them are reluctant to make progressive decisions. And then, of course, the digital rights experts are still fewer in number, even from a legal angle and technology. So there is need for more of these people. And then, of course, the space within which these digital rights are enjoyed is fast shrinking. Of course, we got key lessons from our experience. And some of the lessons we've gathered is that collaboration is key if success is actually to be attained in as far as digital rights litigation is concerned. So when you go solo, you do not have a voice, but if you go many, even if you're small organizations or individuals, you have a stronger voice that can lead actually to success. And then also civil society, the ICT sector also play a big role in as far as digital rights litigation is concerned, especially by coming together, engaging in partnerships, capacity building, and doing all those other activities that aid effective litigation. We also discovered that wide consultation, especially with experts when litigating digital rights, is very important. If your case is to be stronger and if you're to build evidence and to be successful. And it is also, this is a form of public interest litigation, which is also an important avenue. And also for the tech companies, we realize that the leaders of technology companies need to be held accountable, especially for the decisions they make, such as the internet shutdowns, where they just turn off the switch and so on. But beyond those, there are resource constraints across the continent for organizations that engage in these processes. And we've also seen that research and documentation is key, evidence-based research and documentation, if this litigation is to be effective. And then, of course, precedents on digital rights litigation are also growing, and we need to take advantage of these precedents that are growing. Advocacy, of course, as noted earlier, is important. And also intermediaries are quite helpless in this drive for effective litigation because they're usually stuck between complying with the regulatory directives as well as observing human rights. Sometimes they're forced to think of keeping in business by complying with those that have control over their licenses, who can revoke their license and permits, and then, of course, the consumer or us, the people who use their services, end up suffering. And of course, courts are very critical in this whole process. They play an important role, as you have seen. That's why we're here deliberating about these digital issues. Yeah, so for CPESA, that is what we have seen. Maybe if this is where you want me to go specific and speak about the South Sudan case, I can also continue. I wouldn't want to take everybody's time.
I think because we didn't play the video at the beginning, we kind of have some more time. So you could tell us about the South Sudan case as well.
Okay, very great, very great. So recently we tried to come up with picking some lessons from digital rights litigation, and we picked on Sudan as a case study where we saw some important lessons that were emerging from there. But in brief, we discovered that South Sudan is one of, Sudan, sorry, confusing South Sudan and Sudan, is one of the leading countries where internet shutdowns have actually been many, enormous, and on the increase. And of course, the recent ones, of course, were there in June and October last year. And of course, Sudan has come up and made some legal precedents that arise from litigation against disruption. For example, in June 2019, from our discovery, that there was a Sudanese lawyer who lodged actually a lawsuit against the internet shutdown, though this case was brought on individual or in personal capacity. So the court actually ordered that the services should be restored for him alone. And indeed, the services were restored for him alone and was the only person who had access to the internet in the country. So when he realized the fundamental nature of his case and the impact it had, so he lodged a class suit. And of course, in July 2019, court again ordered MTN, Sudani, and Zain to restore services of all, of course, of all consumers or customers, and indeed that was done. And in November 2021, the General Court of Khartoum, for example, ordered all internet service providers to restore internet services to all subscribers in response to a lawsuit raised by a Sudanese consumer protection organization. And of course, national security and state of emergency had been raised as the grounds on which the internet was shut down. However, the judge dismissed the argument of national security and state emergency and issued an arrest warrant for the chief executive officers of the telecom companies for not restoring the internet. And indeed, on November 18th, the same year, 2021, the telecom companies actually restored the internet of all the subscribers. So from that, what we have picked, or generally from our experience as an organization, and from that case, is that one, we cannot stay put and keep quiet about what is going on. One, we need, as civil society, individuals, experts, organizations, academia, to develop position papers, which can be presented to stakeholders like Parliament, for example, for progressive legislation, courts, if we want to get sensible decisions from them. And then we can also engage at the level of making of laws, such that when they are still at the level of bills, we can make analysis and point out the gaps and show way through which those gaps can be bridged. And even for laws, we can even make proposals for amendments of the laws or even total repeal of those laws. Then we can issue press statements which highlight issues that violate digital rights and freedoms. We can write widely on these issues in newspapers and other media platforms. We can also make use of international accountability mechanisms such as the Universal Periodic Review, which aims to assess the human rights record of the respective countries that usually implement these regressive measures. Then we can also engage directly with tech companies in ICT rights promoting initiatives, such as jointly implementing activities, raising awareness, and also promoting the integration of human rights in business. Partnerships and coalition building, of course, is key, and also capacity building of the various stakeholders is very important. Yes, that is it for me for now. Yes.
Okay. So I have picked up a lot of the things you said, but for the sake of time, I will ask Catherine to make her remarks, and then I will ask all the panelists to just join me into a discussion. If the participants at this time have questions or they have anything they would like to raise, I encourage you to use the Q&A function on the chat to just raise your questions. Catherine, I can see you're ready for us. Please welcome.
Hi, Catherine. Can you hear me now?
Yes,
Perfect.
we can.
Okay, my apologies. The internet here is quite problematic, so I'll beg to turn off my camera so I can preserve some bandwidth, if that's okay with everyone.
Yeah, that's fine.
Okay. So I would like to pick up actually from where Victor, ended. He made a remark about how the judiciary is very important, in this cause. And indeed, the judiciary is quite pivotal in ensuring justice and accountability. And in most cases, that they've achieved these through standard setting decisions. And we had Peter speaking about the Togo case and the precedent that they set there, ruling that the internet shutdown in Togo in 2017 was illegal. Currently, well, in contemporary times, the internet has become an integral part of everyday lives, including for judicial officers. We normally think that they are, far away from us, but they're part of us. So the internet is also important to them. And when we look at this, it has created massive opportunities, but also is starting to pose enormous challenges, to the enjoyment of many rights which have already been, mentioned, especially freedom of expression, media rights, information, education. During COVID, we saw how the internet played a crucial role, health rights and other rights. So what we're seeing now is a growing trend on state restrictions and inhibitions, to access online platforms across the continent. And this really has impeded the expansion of civic space. And that does not only affect the other citizens, but the judiciary is part of this, civic space. So they're also affected by these restrictive measures that governments take. And when we see what the trend that states, are taking, they're becoming more lethal, especially, those leaders that have stayed in power for decades. I think Victor or Peter mentioned that you see them holding on to power, and such leaders will not hesitate to go overboard, to disregard constitutional standards and international norms, relating to digital rights. Despite actually ascribing to most of the international legal frameworks, freedom of expression and digital rights. When we look back 10 years ago, it was really easier to gag dissenting voices offline. But many governments in Africa really have discovered what we call the internet. And with the advent of the internet, it's harder to regulate online speech because critics, could be anywhere. So that brings up issues of jurisdiction also for the judiciary. And we saw that in the Stella Nyanzi case, where, the question arose of where did she write this criticism from? Do we have jurisdiction to hear these cases? So it's now easier for governments to control rather than regulate. So unplug the switch, turn off the internet, and let the people go quiet. And many times they actually leave a portion of the internet available to government officials, like it happened in Uganda during elections. And listening to Victor speaking about the AIRA study, I think a lot of countries still possess obsolete legal and policy frameworks, and these are mostly colonial, and they, of course, unnecessarily hinder online access, including arbitrary shutdown orders. We've seen or we've heard about the countries on the continent that have implemented internet shutdowns, and often I think what we're looking at is, they do so without legal backing, and for those that cite laws, we're always seeing ambiguous, obsolete provisions from legislative frameworks, ranging from, say, communication acts or computer misuse laws that have broad national emergency or national security definitions. And that has really given a lot of governments leeway to abuse and misuse the law. So, for example, when you look at DRC, the telecommunications framework law, it allows the government to ban the use of telecommunication facilities. And it says, I think, in full or in part for any period of time as it deems fit in the interest of public security or national defense, or for any other reason. And this has really been used severally to curtail internet access during elections. And the same thing happened in Uganda during the 2021 elections, where the Communications Commission, came out and ordered all telecommunication services, to block internet gateways and shut down access for users until further notice. And they did cite the law, but when you read the provisions of the law that they cited, sections 5.1 of the Act and 56, they're very broad and ambiguous. So that means that is where the intervention of the judiciary comes in. So our intervention with the judiciary, in collaboration with other institutions, especially UNESCO, the American Bar Association, ICNL, has really been aimed to strengthen the rule of law and human rights on the continent by reinforcing, the knowledge and capacity of judges on international and regional standards on freedom of expression, access, media rights, as well as challenges related to the internet. So for the trainings that we've had, they're mostly geared towards achieving, so we align them to sustainable development goals, especially goal 16 on access to information. And this seeks to promote peaceful, inclusive societies, provide access to justice for all, and build effective, accountable, and inclusive institutions at all levels. So we hinge our trainings at the beginning. We're very clear to these judicial officers that we are feeding into some sort of framework. So the SDGs, we are feeding into the Agenda 2063, of the Africa that we want, that looks at democratic values, practices, and universal human rights principles. With UNESCO, which has actually now initiated a robust training program for judges across Africa, we started in 2019 on the sidelines of the Right to Know Day. We convened chief justices, Supreme Court judges, Constitutional Court judges, High Court judges across the continent here in Africa, including ECOWAS, ESCG, and African Court judges for a 2-day training on freedom of expression and digital rights. So for the first time, actually, I saw these judicial officers sitting in a training for the whole day up to 7 p.m. because, the sentiment was, we need this information. These are new sort of evolving trends that they have never probably learned about. So they're actually learning something new. And many judges came to me and said, if we had had this training before ruling in certain cases, we probably would have ruled differently. So the 3-part test, in restricting expression is very important. And we're looking towards equipping most judicial officers across, the continent to understand, how to limit freedom of expression, including internet shutdowns within the law, if at all. So a lot of them are showing appreciation of these trainings. And last year in Nairobi, actually with Victor, we had the first training of trainers where we got 15 judicial training institutions across Africa, train the heads of those judicial training institutions, who are mainly constitutional court judges or high court judges, on digital rights and freedom of expression. It was a 3-day training, and the plan is to work with judicial training institutions, actually, to hold workshops and conferences in order to deliver these trainings now on a national scale. So bring together judges, members of the judiciary from various regions, and encourage enhance dialogue amongst the different, judicial systems, encourage mutual exchange. We have judges from Sudan actually were part of that training, and they gave the experience that spoke about the case that Adri just has spoken about. And there is willingness actually when you speak to these judicial officers to use their roles to sort of promote expression, promote digital rights, but they're also telling us, give us the equipment. We don't know, we're old, some of us, are old judges, so we don't have time. We've not had time to read through these emerging trends. So give us the information. And I must say that the few judges have ruled in freedom of expression cases, some of the judges who have participated in these trainings, and we're seeing a positive trend of jurisprudence coming out, proper application of the 3-part test. For example, in the Uganda elections season, where they had banned journalists from covering courts rather covering the elections. We saw the judiciary coming out very positively to say, no, they must cover elections, and they use the three-part test, and the comparative jurisprudence relating to that. So I think as AIRA, we really need to come together, like Adrian said, more organizations, the more the merrier. In part, work with judicial training institutions, work with the bar associations across the regions, and just give them this information. I know UNESCO has extensively come up with material, Columbia University as well, the Global Freedom of Expression program. I think they have some materials as well that they developed. So we can pick all those materials and put them in a pack, and approach these judicial officers. I think at the end of this month, we have a training for the lower cadre judges, rather magistrates in Uganda. And we're doing that with a judicial officer. The vice president of the East African Court will be part of that training. So the goal is also to use judicial officers to be a part of the training as well. So I think I'll stop there, and we can pick up later on.
Okay.
Thank you.
So I'm not sure if it's only myself who has challenges accessing the chat, or it's just everyone on the call. Probably we might run. I think maybe it's a me problem and my desktop problem, but we'll persevere. So now I bring all my panelists together and I start asking them a bunch of questions, right? And so Victor, I just want to see if you're still on the call, if you went to sleep. I hope not. Because first question is to you, really. And I think for me, it's the ease in which, so as the issues are coming out, and she's also mentioned that you were training the judiciary, I think I want an appreciation of the approaching the regional mechanisms that we have in Africa. We have diverse regional mechanisms, right? So it's easy. So when Peter said they're able to approach the ECOWAS court, and then now we have maybe other regions, for example, Eastern Africa, Southern Africa, and I'm not on even the African Union, the African Commission. I'm not exactly sure to the extent to which these platforms or these courts and regional mechanisms are accessible, if at all useful in our advocacy. So I think my first question to you is, how do we engage regional mechanisms and other regional courts in our advocacy?
Thank you, Catherine. I think the first is important to just recognize that, like Catherine, the other Catherine Anita mentioned that, we have our judiciaries are at different states of maturity in terms of digital rights jurisprudence, and that is bearing on, part of it is a capacity issue, part of it is because there hasn't been any litigation brought before them to enable them exercise their minds on these issues, and also taking note that these digital rights issues were not taught in law schools when they were students. So we have to appreciate the dynamics across different countries and, of course, different curriculums and different legal systems. But, of course, noting that, human rights standards are human rights standards, and it doesn't matter the specific national mechanism. Based on our interaction, I think most of the courts and training institutions are very open to this kind of support, resources and materials. And, because the issues are new, they're also faced with increasing, the courts take judicial notice of what is happening in society, and good decisions require that, we start with the lawyers who actually are, like Kedrin said, we have to start with the lawyers who are bringing these cases. So if they're able to frame the issues properly, highlight the correct provisions, then it gives the courts some meat to chew on. But at the same time, the courts need to have their teeth ready to chew this content. So we need to also work with all these courts, the regional courts, and the national level training institutions to bring together this content to them, since we have some expertise and that expertise can be shared. I know most of the regional training institutions have, the national training institutions have regional coordination mechanisms, which has been part of a move to standardize curriculums across the different regions, and those could be useful avenues to engage, to bring this information to them. So I think generally, in my view, they are very open and receptive to this. Thank you.
Thank you so much. I think for Peter, my question to you is, I once when I was, my first session at RightsCon was about regulating tech platforms or regulating just tech providers abroad and their impact in Africa. And you mentioned the work that you're doing around export controls. And my question is, so how, and I know that as Access Now, you have this tracker where you're tracking the Biden administration and everything that they promised with regards to export controls. So I really just want for you to maybe elaborate more on this and how this would help us.
Sure, thank you. Yes, we really do try to track how countries export technologies that might be used to censor or to invade people's privacy, like spyware. And there's been a lot of news around NSO Group and the Pegasus spyware tool that's been used by governments across the world to attack human rights defenders, journalists, et cetera. And so one of the ways that we're trying to contain this export of these harmful tools is through export controls, and that's laws and regulations that governments impose over the export of certain technologies out of their countries. And these controls started, of course, during or in response to the trade of conventional weapons. So arms manufacturers, guns, military material, and the like. So these export controls were originally developed, to ensure that these kinetic weapons and conventional weapons weren't going to, say, the wrong folks. And we are trying to adapt this to the digital age. And one way is to target those technologies that could be used to create harm online, and that's censorship tools. So some examples of that are deep packet inspection tools and filtering technologies sold by, say, the US company Sandvine, which we have found used in Russia right now to help censor the internet there, as well as in Belarus. So they have evidently no problem selling their tools to dictators with full knowledge, likely, that those tools will be used to harm human rights. And similarly, there's some great reporting around the Israeli company Allot, that's A-L-L-O-T, showing how their deep packet inspection and filtering tools are being installed by telecoms, probably after being procured by governments all across the world. And so we see reporting on, I think, Myanmar, Nigeria, I believe Tanzania, I think other countries in East Africa, Kenya and Uganda have been rumored to have purchased these tools from this Israeli company. And those tools have been shown to shut down social media, shut down, in key parts of the internet during protests. And so we believe this is technology being used to violate human rights, and that's being sold and bought with full understanding that these harmful ends are possible. So we want to, in this case, get Israel to impose stricter licensing controls on the export of Allot's censorship tools, just as the US and other countries should. So that's one way. We'll also talk to investors and say, do you know that your funds or maybe a fund that you invest in is advancing these tools and helping dictators, more efficiently take people offline, and that's a whole body of work that we're engaging in. And yeah, again, there's been some good reporting by Top 10 VPN, by Curium, and by Access Now on this.
Okay. I still have some questions, but I'll come back to you. Adrian, I think that you mentioned while you were speaking, you mentioned that judicial officers, or sometimes the courts, are less willing to make progressive decisions on digital rights, right? And so for me, one of the things that stands out is even in for example, the case in Uganda that I mentioned was a case that had been filed by unwanted witness in not the 2020 elections, but not the 2021 elections, but the previous elections before that. And the case was challenging the internet shutdowns in Uganda, actually. And what the court said was the lawyers the petitioner didn't actually frame the question correctly. They didn't show the extent to which over and above then the right to freedom of expression and access to information should not be limited. And so for me, I found the arguments a little bit problematic. And just coming back to what you said in terms of, and even in terms of what Catherine said, in terms of educating judicial officers and educating litigants as well, in terms of how they're phrasing their questions. I think my question is, there are various words in our country, for example, in Kenya, that are not defined. So for example, national security, public safety, and it's always a difficult question trying to argue with government that, you know what, this is it's not proportional and it's not. So I think for me, the biggest question is, how do we strike the balance between, or how do we, I think for me, it's more of a litigating argument or a litigating question, but the question is, how do we also need to consider how lawyers are framing their questions towards these courts? And do we also need to, for example, just have strategies and discussion sessions with how advocates are understanding these issues and are presenting them within the court? Adrian?
Thank you very much, Catherine, for the question. Your question requires too many answers, but I'll try to give the few that I can. But in light of what you said, for example, I want to start just from the case you highlighted, for example. In that case, actually, the judges were saying that you need, that if you're filing it, you need to demonstrate that actually the harm which the public will, or the people will suffer, actually overrides or is much heavier than probably the reasons advanced by the state, such as national security and the like. So it is quite problematic, but all starts, for example, in such circumstances, as we push on, most times, what we ask for example, we have the catalyst for collaborative digital rights litigation. These catalysts are available online, and they're actually 12 in number. And one of the interesting catalysts, or one of the steps to doing the catalyst for collaborative litigation, says that, well, you may actually not achieve your main or intended goal or objective, but by virtue of you filing a case and showing that you have put in a lot of effort and you're stronger, even with different or various partners coming together, can cause enough impact. And of course, besides that, when you talk about the phrasing, for example, the issues, one aspect I want us to appreciate is that in most of these countries we're speaking about, the judges that handle the cases or the justices are actually most times appointed by the executive leaders, who is mainly the president. Except for Kenya, of course, where the process is a bit quite different, but across the domain, it is mainly the president who appoints these people. And of course, the president represents the state, and there's no president who is always interested in activities which would actually challenge their actions, their activities, and maybe actions that show that probably they're not delivering services or they're not doing as they ought to do. So they will come up and oppose it. So, and then for the judge who receives bread on their table, from the president, and they know probably most times the consequences of a particular decision and what it has got on them, they cannot be pushed to make a decision that actually favors the litigant. One, because they fear loss of jobs. Two, they fear also for their lives and also security. And then also number three is that they are in that kind of situation where they have been placed to believe that whatever we do must be in favor of the appointing authority or the government. Nevertheless, that can never stop us from educating, not only even if you're not an educational institution, but skilling the capacity of the lawyers, the professionals that are engaged in litigation, even those that are not lawyers, but lawyers usually help even to draft things like affidavits and putting together the amicus briefs that come in. So we cannot stop at that simply because the judicial system is frustrating us. At some point in time, all this will come to an end and these things will come to light. In a state that has been really subversive of this and really taking adverse measures against these rights, at some point in time, when you have a collective voice, and a collective voice, not just simply a voice, but a voice which is backed by evidence, which is backed by professionalism, which is backed by research, which is backed by proper drafting or good drafting that is quite convincing, then we are likely to get the results we need. Like Kathy alluded and said that some of the judges said, had we listened to you or had a training with you before this, then we would have held actually differently. So the role of the lawyers or litigants should not actually stop at the level of bringing pleadings in court, but it would also require us to attack the whole process from the side of the people who listen and make fundamental decisions and whose decisions are actually listened to. Those are the judges and wherever the prosecutors, the juries that be in the courts of law. Yes, that is in as far as I can respond to your question.
Thank you. And I think you did such a great job because it was such a convoluted question. But the answers are very, I think for me, it stands out that you say we must do more than just draft our pleadings and present them in court. We must look at how our actions are also influencing the people who are going to make the decisions. And I think this is where Catherine comes in, because for me, I think one question, and it has nothing to, it's just something that came off my mind, is in Kenya, for example, in as much as we try to have a very robust judiciary, right? Sometimes our judges get transferred from the human rights court to maybe the taxation court and commercial court. And for me, it would look like, I think I want to ask about your training, right? So when you're working with the specific judiciary training institutes, and just to link it with what Edrin said about going beyond and maybe looking at, are we contributing to the sources of law? Are we contributing to soft law material? And before he talked about developing position papers and developing materials that judges can rely on. So for me, it's have you foreseen some challenges with your training that if you for example train specific judges, then it will be a problem when the specific judges are then retransferred to different divisions or different areas within the court system, and then they're not able to actually attend to the matters. Because for us, for example, such matters would be brought to the High Court, the Constitutional Court, the Constitutional and Human Rights Division. And if a judge from this division is trained on this and then is moved to a different division, then it becomes the person sitting again is still moving with the knowledge. So for me, it's how is the program and how is the judicial program encompassing or taking note of such situations and trying to solve them?
Thank you, Catherine. Well, I think we can do as much as we can, really. How many judicial officers do we have per country? And we must acknowledge that one of the biggest challenges is the resources. Training judges is one of the most expensive things that you can do. Sometimes you have to bring 2 extra people. So it's, however, when you train when you work with judicial training institutes, then the training becomes institutionalized to share with them the curriculum, and they're aware, so they can actually do it internally. So when we do the TOT, it's we are looking at the judges who came for the training, sort of trickling that knowledge down to other judicial officers, including magistrates and judges of across the High Court, Constitutional Court, and Supreme Court. But also, there's been a request from a lot of these judicial officers to sort of have like a handbook, with some of these cases compiled for them, some of these standards explained to them. So imagine you have a handbook on each judge's table on internet shutdowns. Whenever they receive a case on internet shutdowns, they will know that AIRA gave us this handbook, so we can look at it and have read about the comparative standards on digital rights and look at what other countries are ruling. Countries in Africa have ruled, and because they've had some training on the basic standards of freedom of expression, 3-part test, they'll apply that. And even if we have negative rulings in that handbook, they might want to rule otherwise. So we still need to provide them with the information that will guide them. So in as much as some of those judicial officers do not attend our trainings, I think the discussion needs to be towards having each judicial officer have some material that will aid them, when they have a case on surveillance, they'll know, oh, okay, maybe MLDI has given us some material on surveillance, and we have comparative cases on this. We can read and understand the topic better. Like I said, many of them have categorically stated that they don't understand a lot of these, these issues. So I remember, actually, you mentioned the unwanted witness case. And much as it was lost, we still gained, because by then I was working with Article 19 and we filed an amicus brief. And we were admitted. So that was really a great win. And that's what coalitions like AIRA need to be doing in terms of engaging with the judiciary. It may not be trainings, but, bring your expertise on the table. At least try, we'll have national courts saying your organizations that do not work in Uganda. That's the argument of the state. In that case, the state had rejected, the admission of Article 19 as amica in that case, but the judge was progressive enough, to admit Article 19, which is, based in Kenya and it's international. So that was a win, and that opens more doors for other organizations like yours, Access Now, to bring amicus briefs in national cases and show their expertise. In terms of collaboration, I think there are other ways that we can work with the judiciary besides the judicial training institutions. Well, if you want to work with them, you should approach them early, because many times they plan, to include trainings in their calendar. So if you approach them early, they'll make room for that. So AIRA could start making headway with different judicial training institutes across the continent. You can also approach judges directly. Bring them to your conferences. Call the Chief Justice, to give remarks about internet freedom, internet shutdowns, and put them on the spotlight. Identify actually problematic judges and invite them, to be a part of these conferences. That may change some mindsets, and we've done that. Sometimes we feel judges are way above us, but you'll be surprised that you'll walk into the Chief Justice's office and explain to them an activity that you're doing and ask them to be a part of it, and they'll say yes, even without having ever met you. So let us put ourselves out there and bring the judiciary closer to the people, because they work for the people much as they're an independent arm of government. We have bar bench forums across different countries. So some of civil society are lawyers. Let them use the bar bench forums to bring some of these issues to the fore, mostly digital rights, freedom of expression issues, bring them, make them a priority, speak to the leaders of your law societies about this. There's also the African Judges and Jurists Forum. Let's make use of those platforms, to bring digital rights at the fore. Thank you.
Okay. I really love the responses that you're all giving, and especially for what you just said, Catherine, is that we all have a responsibility to, of course, because of limited resources and limited funds. So we must all contribute. And I think the idea of developing a case digest on internet shutdowns, Peter, I hope you're listening, and everyone on this call, I think is really nice. Akijol, please. So I hope that we're all listening, that we all need to come together and bring together our expertise in developing certain things. So a case digest on digital rights could be used across different jurisdictions, could be used across different legal systems that informs how judges are going to decide on such an issues. And I think that's a really great idea. So right now I want to draw attention to the chat, which I cannot open, but there are some questions that have been posted by our participants. And I think Peter has tried to answer the first question that was directed to Access Now. The question was, out of interest, has the Capitan Coalition recorded any cases where governments have conceded and responded to open letters by stating that they were wrong, impliedly or explicitly, or in any other platforms, if not responding to open letters? So because there are some people who are probably watching this live and might not have access to the chat, I will invite you to answer that.
Thanks. And yeah, and I agree. There's so many good ideas coming up here. So short answer is governments do not usually respond directly to us. It's rare if it's ever happened. But for one thing I want to point out is that's why we rely on journalists in a lot of cases, because journalists, if they do report on an open letter, can go, and they do have access often to those authorities and can put them, put the mic in their face and ask them to respond to this open letter. Will you shut down the internet during this election or not? And we rely on that. We also rely on litigation, and litigation is, one of the only places where we can get the government to go on the record as to why it ordered a shutdown. And in the Togo case brought to ECOWAS, the government cited national security as justification, and the court saw through that. The court rejected the assertion by Togo that national security justified the shutdown during those protests. And it's an incredible ruling, and exactly the type of thing we would want to highlight in that case digest or judge's handbook. So I wanted to bring that out. But yeah, I mean, the open letter is, it's a tactic, it's a tool. It's not the only one we have, but it is a good way to start conversations, I think, and to show a broad cross section of actors really want answers from the government and want to hold them accountable. Thanks.
And the next question, I'm not sure if it was directed to anyone, but I will direct it to Edrin. And the question is there any analysis of the extent to which governments have respected decisions that advance digital rights? It would be good to know whether there needs to be any advocacy to ensure implementation of progressive decisions. And I think this can also be answered by Victor from our very able Kenyan perspective. So Edrin?
Thank you very much. In a simple response to that, we tried, for example, I think a year or two back, we did an analysis, for example, on the case, one in Kenya, one in Tanzania, and one on Uganda. Of course, unfortunately, of all the cases, the one in Uganda, the one that was trying to challenge the OTT tax was even never cause listed for hearing and was overtaken by events. Last year, when the OTT tax was scrapped, that was replaced with a 12% levy on data. So in those analyses, we try to score some of the issues that actually or fundamentally affect digital rights litigation. We also highlight some of the lessons that we can pick from those cases. We also highlight some of the challenges that can be picked from those cases for better future litigation. So That is one of the reference points. These cases are available. The case analysis are available on our website, on the CPESA website. You can check there in the resources. The cases are available. But nevertheless, as we said, digital rights litigation is an ongoing concern, so it does not stop. And the calls for more advocacy, there we need to keep advocating, we need to keep working together in partnerships, in collaborative efforts. We need to continue working together in bringing all experts from different walks of life together to ensure that we build stronger cases. So that is the simplicity and of a response that I can give in that respect. Okay, thank you. And so I see one participant has raised their hand to ask a question. I'm not sure if we can allow, I think we can allow the participants, at least so that we can get to hear from our participants. So our technical support, could you please help Idris to ask his question? I think that he raised his hand to ask a question. So if maybe we could just allow him to ask the question. And as we do that, I could read one response that has been posted on the chat from CPESA, which says, some strategic litigation cases are not decided on the merits of the argument, but the political implications. So for example, this is a reason why some cases get pushed for months or even years before hearings or mentions are fixed or even rulings delivered. And yes, we have seen that also in my country. So there's a petition to appeal the decision on our digital identity case, Huduma number, that has now finally been scheduled for, I think, after a year. So, so yes, I agree with the statement. Are we able to let Idris ask his question? Brian? Okay.
Let me follow up on that.
Okay. So as we allow Idris to ask the question, Peter, because you have your video and I will just pick on you. I think for me, I think one of the things that I want to ask is—
Hello?
Oh, okay. Please ask your question, Idris.
Hello, thank you very much for these wonderful presentations. It is just like direct issues that I'm been facing now, because I'm a consultant now with one institution where we are mapping internet shutdown and internet censorship in West African countries. So I'm taking care of Nigeria. My question here is, based on the literature I lay my hand on the researches I went through on Google, I realized that it's easy to understand internet shutdown, but it is very difficult to understand issue of censorship on the internet. How can someone easily identify censorship is going on in a particular country or in a particular part of the country? Let me give example. For example, last month, a Senate president came to my state for a wedding, and because of him, I think either they shut down network or they blocked access to all the telephony services for almost 15 minutes just because of his arrival. Is that one an internet shutdown or internet censorship? That is number one. And number two, on this issue of censorship, because I heard from different forums and from different internet and digital rights advocates saying that censorship is going on in some West African countries. Nigeria is inclusive. So how can somebody go ahead with the advocacy for freedom of and also digital right on internet, especially with the rampant issue of internet censorship? Thank you very much.
Okay, so I don't know if one of the panelists wants to volunteer. I have to volunteer someone. But I think the question was largely, how do we differentiate shutdowns and censorship, right? So you're nodding your head, Peter. I'm going to pick on you.
Yeah, it's a good question. I mean, I totally agree that it is difficult. It is often very difficult to identify censorship online. There's so much that we don't see. There's so much that's in the power of the ISPs, that's in the power of the telcos, or that's in the platform's hands on Twitter and Facebook, to downgrade content, to hide content from certain users, to delete. you know, we do rely on partners and journalists to identify internet shutdowns, but really, you know, we think the onus is on, the burden is on authorities and on telcos and ISPs to tell us when they're shutting down the internet or throttling or blocking certain services. And we haven't seen enough transparency yet. To that larger question of shutdowns and censorship, shutdowns are absolutely a form of censorship. Internet shutdowns, and we're just, I laugh because we're in deep discussions in the Keep It On campaign to kind of update our definition of internet shutdowns, and talking about different elements of what defines a shutdown. And we absolutely agree that shutdowns are a form of censorship, but there are many other forms of censorship besides internet shutdowns. So in our view, if you shut down Wikipedia, for example, a website, you know, a source of knowledge, that is absolutely censorship, but we wouldn't term that an internet shutdown, because Wikipedia isn't used by people to communicate kind of in real time, to organize, to talk about protests as they're happening, for example. And so, yeah, that's not to say it's okay to shut down Wikipedia, to block Wikipedia, but we just wouldn't call it a shutdown. Yeah.
Okay, so because of time and because this is DRIF, I'm going to have to sort of wrap up this conversation, and I can tell that we all have so many things that we want to contribute. And I'm going to ask and invite the panelists to just come in and make their closing remarks. Victor, if you have anything that you want to add on the censorship and shutdown issue, you can do this as you close. And so, because I will start with you for your closing remarks. Welcome.
Thank you, Catherine, and thank you, everybody. I think for me, what is important is that we need to continue monitoring and documenting, and creating these databases and equipping as many people as we can with the information and tools to be able to, as you know, to document and identify when they're happening. Even the last question from Idris really raises a very important question about just how can we identify these things when they happen, because most of the time it is hard to detect. So we need to be more intentional in monitoring and documenting, but also, like Peter mentioned, you know, put a spotlight on intermediaries to be more transparent about the orders they get to shut down or to disrupt internet whenever it is they receive them. So I think that's it for me, and we need to just build more partnership through multi-stakeholder approaches to fight shutdowns from whichever side they come. Thank you.
Thank you. And so the final comment, which is, why is it always the responsibility of CSOs to educate everyone? Judicial officers need to take initiative to educate themselves. In our professions, we all seek professional development without legal support. Yes. So I'm still going to invite you to make your final remarks because we only have 3 minutes. But if any one of you wants to address this in their final remarks, that is welcome. And so for this, I'll invite Adrian to give us his final comments.
Thank you, Catherine, first of all, for moderating the session, and thank you everybody who has participated. I want to end by just re-emphasizing that, as we've spoken much earlier, that digital rights litigation is an area that has emerged and is growing stronger on the continent, and states are increasingly getting to realize that indeed people are aware and that digital rights are not an issue to joke with. So we as advocates, we need not sleep. We need to become a little more serious, work together in efforts. Those who have the resources can put in the different kinds of resources, including the financial, and then of course the mental resources, the human resources, to ensure that we advocate for a common cause in digital rights and consent. So we need not wane or give up early enough. We need to keep pushing, even when it appears that we are losing out on some of the cases. It does not mean that all is lost. but we can keep pushing on and progressing. Yes, thank you very much. That is what I can say.
Thank you. Peter?
Absolutely. Thank you all. So I just want to offer a few resources. First, Access Now, as we said, coordinates the Keep It On campaign, and you can visit our website, accessnow.org, to find more on how to join that campaign or write to me. We also, on the litigation front, track internet shutdown litigation globally. And so we have a spreadsheet that I can share of all the cases that we know of, and that should be helpful to develop that sort of digest. We also have a model brief, and in that model brief, we analyze a lot of these cases. And so happy to share all that within our Digital Rights Litigators Network work. And then, yeah, closing thoughts. I mean, this was, I can't sum up. I think on that point, though, around why it's our job, it's not our job, right? It's not our job. You know, we're not in the business of educating all the authorities who are appointed to mediate our human rights, right? That is certainly not our job. But we are, you know, we are experts, and I think a lot of us do dedicate ourselves and our time and resources to making a better world. And so we take on some of this burden, and we really just ask that authorities do their jobs. And when it comes to you know, censorship and shutdowns, I think one piece we can push further on is transparency from authorities on when they buy this equipment, this deep packet inspection and censorship equipment. What budget are they using? Where's the competitive bid process? Where's the transparency on how that equipment is installed and used and maintained? Is one place I want to see progress. Thanks, everyone.
Finally, my name's Catherine.
Yeah, so I read Kahinde's comments, quite interesting. It reminds me of one time when I was in court, a very controversial lawyer told the judge, I'm not here to educate you. If you don't understand the law, you shouldn't be sitting here. It's not my duty to educate you. So again, when you look at, you know, the other aspects of things that we do as civil society, like journalists, they barely report about their issues. You know, they'll report about doctors earning little money, they'll report about, you know, other health workers, but they're not going to, they will barely write about journalists' issues. So that's where we come in as civil society. And like Peter said, if you're an expert in an area, it's incumbent upon you, you know, to share your expertise in order to make positive change, at least try to make that change. So we can work collaboratively with different organizations. If you need legal support, I mean, MLDI or Media Defense has supported lawyers around the world, including financially, to challenge some of these cases. I do work with MLDI. So if you need that connection, please reach out. We could support lawyers who are doing litigation in digital rights in that front. I work with Peter, I've worked with Peter and Sipesa, you know, to bring submissions to the UPR system at the UN. So let's not use one front, let's try and use every available opportunity to bring these issues, try to, you know, raise our voices and create change where we can. Thank you.
Okay, I'm so sorry to have to rush all of you to conclusion, but we are 7 minutes over time and I really had to do this. Thank you so much to Paradigm, but I think that our concluding and final remarks on what we need to do in terms of case digest, I didn't even get to what we need to do at international level. Probably we need to define General Comment 34 and revise that with regards to internet shutdowns, looking at what actually that means in terms of limitations and access. But I feel like there's so much more that we need to do, that we do as well as Article 19 at both at the regional, national, and international levels. So I don't think that I am censoring Ashnaut. I don't think that she has final comments. So because of time, I'm going to have to end the session. I thank you all so much for your time and your dedication to stay with us until the end. Thank you very much.
Thank you everyone for joining us. Please join us for our last session, DRIF 2022, as we land the plane together, coming up soon, and hope to see you. And thank you so much for an engaging session.
Thank you.
Yeah, thanks.
Thank you, everyone.